everyone. Today we are going to discuss the topic on trade secret. I am Dr. Bindu Malviya, Professor of Intellectual Property Rights, Department of Management. So let us start with the introduction. What is a trade secret? So friends, trade secret is a secret related to the trade, related to the business, or it can be like here you can see it includes any financial information or any technical and scientific information, commercial information, any negative information. So all these information constitutes a trade secret. So the definition, the meaning of trade secret here. A trade secret is a formula, pattern, physical device, idea, process, or compilation of information which is not generally known or reasonably acceptable, by which a business can obtain an economic advantage over competitors or the customers. So this is the meaning of trade secret. So here, what are the important aspects? Trade secret is it can be any formula, it can be any pattern, or depends upon different various elements of trade, like the pattern of doing a business, or any physical device. If any company has designed any physical device or invented any physical device, that can also be a trade secret, or any idea, any business idea, any strategy for doing a particular business, or any process of manufacturing any particular product, or any kind of ingredients for making a particular consumable product, or compilation of information, like in case of computer program, or in case of maintaining any database by various companies. So all these constitutes the trade secret, and all these things are considered as the economic element, or it gives the economic advantage over the competitors and the customers to that particular trade or the business. So what are the potential trade secrets? So it may be any formula for a sports drink, then it can be any several method used for professional pole stars, and recipes in case of food, in case of eatables, it can be any recipe, or it includes new inventions for which a patent application has not yet been filed. So if anybody has invented any particular device or any particular product, so if the person is not interested in going for a patent, then at the initial stage the person may prefer to obtain a trade secret, which includes marketing strategies, the way of doing business through which the possibilities of success increases as compared to the competitors. It includes any manufacturing techniques, or in case of computer, it can be a computer algorithm also. So these things can be protected, these confidential information can be protected by way of trade secret. So what is required to maintain a trade secret? As the name suggests, trade secret. So something which is secret. Secret means any information which is passed from one person to another person, or to a group of persons, that is a secret, on the condition that it should not be disclosed to the outside world. So there are various ways to protect our secret. Like friends, why it is important? Trade secret. So can you understand what are the businesses, what are the various, in what products this particular trade secret is being protected as the intellectual property. A very famous example is Coca-Cola, the formula of Coca-Cola. That is a trade secret over more than 80 years. So it can be any like you must have heard about Amway business. So what Amway business does, it has a different way of selling the goods. It has a different methodology for making customers, for distribution. So unlike other selling channels, it has a different unique way of selling the product. So like in case of banks and other financial institutions, where the database of the customers is very, very important, because all the service industries aims at increasing their list of customers day by day. As the business grows, as the business expands, they are desirous of increasing their list of the customers. And this list is the raw material, or this list is the, you can say, the foundation of that particular business, especially those who are into the service industries, because the customer is the only source through which they can increase their profits. So this can also be a trade secret. Like if you go to a bank and if you ask to give 10 names of the customers along with their contact number and their information, will they disclose that? No, because they don't want to lose their customers, and whosoever is the customer, they want to retain those customers for a longer period. So this is how the trade secret is protected in different types of business. So first thing is restrict access. This trade secret, it restricts the access that only people, those among whom this particular confidential information lies, only these people have the right to access, and rest of the world is restricted from the access to that particular information. Like log is away in a secure place such as a bank wallet. So everybody cannot use that. Only those people have the key or have the access to that particular information. It is like, you can say, like for using any particular online facility, they ask for a password. You must have you must register for a particular website or for a particular application, and then you are asked to generate a password. So this password is for you. Only you can use that particular platform because you have the access, you have the password, and others are restricted. Limit the number of people who know the information. So you can limit as per your own willingness, that how many people you want to share that particular information, and you can choose who would not be included in that particular, in sharing that particular information. Then have the people who know the trade secret agree in writing not to disclose the information. So it is executed through signing of a non-disclosure agreement. So how to rely on others? Simply you make a secret and you ask the other party not to disclose it to anybody. So do you think that that particular secret will remain as a secret? Like among yourself also, you must have seen that whatever said, like for example, any information which you have and you share with someone, and you take the promise also that please don't share it to anybody. So what happens? The news, the information, the more you insist that it should not be shared with anyone, it is shared with more and more people, and every time when the information goes to the other party, that party says that please the party shares and promises not to share to others. The same thing is repeated with the next person, and the same thing is repeated with the next person. So in this way, the secret is not, it does not remain as a secret. So what to do with this particular aspect? So by signing of non-disclosure agreement, you can restrict or you can stop the other person who knows the secret from sharing that secret to the other party. So have anyone that comes in contact with the trade secret directly or indirectly sign non-disclosure agreements and mark the written material pertaining to the trade secret as proprietary. So whatever is the trade secret, that has to be, that must use a particular mark that this particular process or this particular device or idea is proprietary, means it belongs to some person and the person are having the right to use that, and it prevents the others from using that particular information. So now, why one should go for the trade secret? There are various other ways also for protection of the creative idea, for protection of some new ideas and new ways of process or device or any other thing. But what are the advantages over the other intellectual property rights? So first thing is unlimited duration. So friends, in the previous lectures, while discussing about copyright, discussing about the trademark and the patents, we have seen that these intellectual property rights are valid for a limited period of time. In case of copyright, you all know that it is for a period of 60 years, from the 60 years plus lifetime of the author. In case of patents, it is for 20 years period. In case of trademark, it is valid for registration is for 10 years, and further, if the proprietor wishes, it can extend by renewing the trademark protection. But here, the main advantage is it is available, it is valid for the unlimited period. As much as the proprietor wishes to have the particular information as a secret, it all depends upon the proprietor. There is no limited period as such. This is the biggest advantage. A particular information remains a secret till it is a secret, till it is a confidential information. Once it is disclosed, it is no more a confidential information. So it depends upon the people, those who know that particular information, to what extent, to what duration they want to keep it as a secret. That is the lifetime of, that is the duration of the particular trade secret. Second important thing is, your protection is theoretically worldwide. Whatever thing is protected through trade secret, it is not territorial in nature. Like in other things, you have seen that if you have got the registration of your patent, it is valid. If you are registered in India, it is valid in the boundaries of territorial boundaries of the country. Similarly, if you are going for international conventions, PCT, then it will be valid for the countries who have signed the PCT. But here, this is not the limitation. Here, once the persons have signed agreement to continue with the particular information as a trade secret, it is valid worldwide. The next is very important. No application is required. There is no need to approach to any particular government office, approach to any patent office, copyright office, trademark office, because here this particular intellectual property is safeguarded, is protected by the secret information among the people. No registration cost, since there is no application, no registration is required, there is no particular office for registration of trade secret. So there is no cost involved, no public disclosure or registration with the government agencies, and it becomes effective immediately. As soon as the information is prevented, if is protected through the confidential information, through some agreement, that becomes effective from the date itself. You are not supposed to wait for a particular authority to grant permission, to grant approval for particular intellectual property. So see, here are some examples while discussing the topic trade secret. We cannot forget these important companies. Coca-Cola, as I told you, the formula which is used for making the soft drink, that is still today also it is a secret. Otherwise, you and me or anybody could have been able to produce this particular cold drink, but it is not possible because the formula is secret to the particular organization. Then Big Mac special sauce. McDonald's, you know very well, very famous brand for burgers. So they use the ingredients which they are using in this burger, the sauce which they are using, that is very special, and that is manufactured with some special formula, with some special process. So that is a secret. In KFC kitchen recipe. Okay, KFC is also very famous in India, especially for the non-vegetarian people. So they claim that they use some special herbs. So these herbs are very confidential among the people of the company, and which they never disclose. And because of this particular confidential information, they are having a competitive edge. And WD-40 formula, this is a washer. So this is also having a trade secret. So as I told you that KFC is one of the very popular, famous trade secret. That is Kentucky Fried Chicken. So it claims that it has 11 herbs and spices which lies in the wallet. Few people know it and they are contractually obligated to secrecy. Say this particular, what are those 11 herbs? That is the secret among some people of that particular company. That the ingredients are mixed by two different companies. Another thing is, these ingredients are mixed by two different companies. And after that, these are combined together. And even these two ingredients are mixed at two different locations. And then they are combined in the third place. So, yes, this is a secret, a big secret. So, to mix the final formula, a computer processing system is used to blend the mixtures together and ensure that no outside KFC has the complete recipe. So, this is how the KFC is able to protect the trade secret and how it is done. So, initially, any company, because as we know that going for a patent or going for any other intellectual property, it is a very complex process and it is time consuming and it is valid for a limited period of time. So at initial level, any company can go for the trade secret. At a later stage, it can identify whether that particular invention is patentable or not patentable. If it is not patentable, then it cannot be granted. And then if it is patentable, then they can go for the application of patent. But at the initial stage, they can protect their business idea, their confidential information with the help of the trade secret. So, when we compare what is the difference, what are the benefits of trade secret and the patents, here it is very clear that in case of trade secret, registration is required. Very less cost is required. Only you have to sign an agreement paper. So, second thing, in patents, you have to pay registration fees and later on fees for this examination and other things for the renewal also, for the grant of the patent also. At different stages you have to pay the registration fees. It includes some cost. Second thing is, as far as trade secret is concerned, it can last longer, many times more as compared to the patent, because patent is valid only for a period of 20 years. And if in case, in certain circumstances, if the government has gone for the compulsory licensing, then only for 3 years period. And no public disclosure is required, but in case of patents, you have to disclose to the government. Whatever your specification, whatever is their invention, you have to disclose to the government for the purpose of publication. And then, now, what are the remedies of misappropriation? Now, somebody, despite of taking a lot of precautions, that your trade secret should not be disclosed to the other party, but still, like, as you know that in any organization or in any business, or there are people who believe in law breaking, who are lawbreakers. They will not follow you, or for some in self-interest, or for some their own interest, they can make a breach of a contract. They will not follow your promises. So in that case, what will happen if somebody is involved in disclosing the secret? So first thing is court order to stop the misuse. Once the culprit is known, the misappropriator comes into the knowledge of the person, then the court can order for stopping that person through by way of injunction to stop such misuse. Then second thing is monetary damages. Whatever loss has been incurred by the proprietor by misuse of that particular trade secret, the court can ask for actual damages or amount by which the defendant unjustly benefited from the misappropriation. This seizure order, it can also go for seizure order. This is an administrative action where the victim can be asked to go approach the defendant premises and go for the seizure of the particular information. Then precautionary impoundment. So of the other articles that include misuse, trade secret or the products that resulted of misusing. So these are the remedies for in case of the misappropriation of the trade secret. So now we will see what are the defenses which are available for the misappropriation. First thing is independent creation. First of all, similar formula created with his own knowledge. If somebody has created a similar formula, not by copying somebody else's idea, but by own idea, then you can be saved. Second thing is unclean hands. The owner behavior is morally wrong. If somebody is not in clean hands and that person is morally wrong, then that may be ground for defense. Latches. Latches means unreasonable delay in asserting a claim which may result in its dismissal. So sometimes the defendant tries to extend or delay so many things so that ultimately the things are put up in a dismissal. Absence of secrecy, protection measures. And the fifth is the privileges. Sharing the information before media at court trial. So this is why when the court asks for sharing some informations, some media, then you have to follow the order of the court, because denying the order of the court is contempt to court. So you have to disclose the information, whatever is being asked by the court during the trial. So these are the various defenses in which the defendant or the respondent can seek protection or can be saved from the allegation of misappropriation. So friends, today we will see the latter part in the upcoming lectures. So we will stop here and goodbye. We will meet in the next lecture. Thank you very much, class.